My name is Ted Starr. I represent Chancey Hodges, and if it pleases the court, may I proceed with my argument? We're here to discuss and support the decision of Judge Day to exclude the criminal convictions when asked prior to the trial. And the question here is whether Judge Day exercised sound discretion in determining whether those convictions, which were older than 10 years at the time of the trial, to exclude those from evidence. Now, lawyers, when they're making these arguments, go to great extremes. I mean, counsel just told you a moment ago about 6 years from release from confinement was the date of the trial when the witness was testifying, and release from confinement is the federal rule. It's not the Florida rule. We don't count release from confinement. We count convictions. That's when the.
Yeah, but there are cases where the convictions were even more remote.
Well, there's cases
so
where.
Why wasn't it an abuse of discretion in this case?
Because the judge asked all of the reform questions that the court would ask in making the decision. They asked, was he a resident of the area? Did he maintain his employment? The court was told he was married, he had a child. Those were things that show evidence of reform. That's exactly what the Bracewell case tells us to do and tells the court to do, is check to see if there's evidence. If there's no evidence of reform, Bracewell would tell us that the convictions are entered. Here, there's evidence of reform. Specifically, those questions that the trial court asked at the motion limine session are exactly what the court was taking into account. Now, the court did find out what the convictions were. They were drug charges. Certainly, the court would want to know that there wasn't a perjury charge. Perjury is given a different category. Even that's the Ward case cited by both parties. But in these cases, they were drug charges. And it's appropriate for the court to ask.
Well, the statute applies to any felony, so it really doesn't matter. It just.
Well, it doesn't. You're right. It doesn't matter, except that the second part of our evidence rule does pertain to crimes of dishonesty, and the judge was putting them in the correct category. But absolutely, a felony would fall into the first category of our rule of those being impeachable, unless there's proof of reform. And in this case, the judge asked the exact questions. That's the court's exercising its discretion by taking that into account.
The judge doesn't say anything in his order about reform. He just says they're remote.
He just says that, unfortunately, that's right. He just says that they're too remote, and because that's the language of the statute. There's even in a case that was not cited in either of our briefs. It's the City of Miami versus Ross. It's a wonderful case for the plaintiff because exactly what happened in our case happened apparently in the City of Miami case, where the appellate court in that case in the 3rd District said that the conviction for worthless checks was too many years. It's exactly the ruling, and that case is cited at 695 South 2nd 486.
Well, they don't say how many years in that case.
No, they don't say how many years.
Right.
It's not a helpful case. And so this is exactly what happens, is they make the ruling based on the information in front of them, but they don't tell us what the number of years is, and neither did the trial court in this case identify the elements of what was taken into account. The court had the information and said it was too remote, because that's what the statute requires, but the court didn't say it's too remote because 1, 2, 3, 4, 5. But that doesn't mean the court didn't take the information into account.
This whole notion of reform, isn't that in the case law and not in the statute? The statute just references remoteness in time as to have no bearing on the present character of the witness.
Well,
it doesn't. The reform language comes out of the case law.
But that's the amazing part about this exact language, because the Bracewell case is the seminal case in this regard. The language of the Bracewell case became the statute, and exactly what happened in the legislature stopped where the court in Bracewell said, after determining the witness's credibility, there is nothing in the record to show that the witness has not reformed. That's the Bracewell case. In that case, the Bracewell case says if there's nothing in the record to show that the witness is not reformed, then the convictions come in. That was not made part of the statute, but certainly, right. But if you look at it, the legislators followed the Bracewell case, copied the language almost exactly, exchanging the word credibility for character, and created our statute. And so when the Bracewell case go on to say that there's nothing in the record to show evidence.
Bracewell, are there any other cases that reference the reform?
I think Yeah, I mean, yes, in some respect, these cases that are against me, the Children's Palace case cited by them, that was 40 convictions for over a long period of time where the court determined that person had not reformed. I mean, it's in the reverse where we see these courts, when they're letting these convictions in, say there's no evidence of reform. So, it's just the opposite. So when we have evidence of reform, especially when we use the Bracewell language, we see that, yes, those convictions should be excluded. That's the point of the court having that discretion. And that's the Florida rule. It's up to the court's sound discretion. And that's exactly what Bracewell tells us, and that's what our court system tells us, is that's up to the trial court's sound discretion.
Let me ask you, in exercising its discretion, where, if at all, in the weighing process, does the trial court take into account the need for impeachment, in the sense that their argument is really the medical provider's testimony was key in this case, and all they had to go on was his subjective complaints, so his credibility was critical?
Well, I don't know if that's exactly accurate, Your Honor, in that...
Okay, well then, let me stop you there. Tell me what the doctors relied on in diagnosing this gentleman, aside from his subjective complaints.
The jaw surgeon had an MRI of his jaw before he recommended surgery on his jaw.
And what objective findings did he get from the MRI?
I don't remember the exact medical finding, but it was that his jaw was displaced and needed to be surgically repaired. In addition, the orthopedic doctor, not a pill doctor, orthopedic doctor is the one who found that he had testified that he had a torn cartilage or torn medical element, and that was part of his bulging disc, and that tear would have caused him a significant amount of pain, and that doctor testified that was objective. The chiropractic physician even testified that there was muscle spasms, which would have been objective. So, these were some of the objective things that were part of the testimony that was available for the jury to hear, that there was objective findings as well as obviously the subjective complaints of pain, and even the plaintiff testified to his complaint. And when he testified in such a way with his jaw that you could tell he was in pain, and I think the jury saw that. So, these are the objective things that were available to the jury, and probably, the whole point of our statute allowing for the exclusion of criminal convictions is so that this person, Mr. Hodges, is not tainted by this criminal conviction.
No, the whole purpose of this statute, though, is to allow people to be impeached with their criminal convictions. We're not talking about character evidence here. We're talking about impeachment with a prior felony conviction,
right?
Which is specifically permitted under this statute.
But the statute
unless
it's
so remote in time.
Absolutely. And so at some point we needed to, and Florida doesn't draw this bright line, and even the federal bright line is just a presumption, shifts the presumption to it being excluded after 10 years versus before. But potentially in a federal case, if you have a 9-year conviction, you can still ask for it to be excluded as long as you can show all the other elements that are necessary under the federal statute to exclude the conviction, and one of those obviously would be reform. In the federal statute, your showing is not as critical after 10 years. We don't have that determined. When the showing should be critical or not. Someone can ask 2 days after their conviction. If they can show reform, they can ask to exclude that. Not likely to get it, but somebody 20 years after their conviction, if they can't show...
Didn't you just write the remoteness element out of the statute by saying 2 days later if they can show reform?
Well, remoteness isn't defined. So, right, that would not be, arguably that no one would agree that 2 days would be remote. But 20 years is also...
Well, but we're not 20 years either.
No. But we're not. But the remoteness has to do with whether the person shows evidence of reform. If somebody during the 20-year period continued to not have any evidence of reform, I'm not sure what that would be, then they would not be able to exclude the conviction. That's the point of the statute. That's the point of the Florida rule, giving the court the discretion to determine that. That's why I bring us back to the Bracewell case, because that's the case that created the statute. And, when Bracewell talks about reform as being an important element of it, I think that's exactly what we need to look at. That's exactly what the trial judge needed to look at. That's exactly appropriate. And so even where appellant, using the Children's Palace case, says we cannot conceive of a reasonable juror who would not have received a significantly different impression of the victim's credibility had the proffered evidence been admitted. In that case, there were 40 convictions. And so that court said, well, clearly that juror would have a different impression. In our case, with our 10-year-old convictions, and with Mr. Hodges' evidence of reform, the court can reasonably say, I don't know that a jury would automatically take that as a different impression of Mr. Hodges, just because he had 4 convictions after 2 arrests when he was 20 years old. And after he had, and then forcing him now to bring evidence in of, I've had a family and I've been working at the same job for 9 years and I'm a cook, and basically for him to show that evidence of reform to overcome that overwhelmingly prejudicial information of him having those convictions. Instead, we do that with the trial judge beforehand, and the judge appropriately says those convictions should be withheld. I mean, that's the crux of our response to the city's attempt to bring these criminal convictions forward as impeachment of Mr. Hodges.
Okay.
Thank you very much.
Okay, thank you.
Your Honor, may I have-
Yes.
Thank you. I'll be brief. Happily, the plaintiff counsel just said he doesn't know if the jury would have found this significant. That's right, and that's what the Florida Supreme Court in MacArthur said. Because we can't say that a jury would or would not have considered this in finding its verdict, this is reversible error and abuse of discretion. Just to touch on a couple of brief things regarding the medical testimony, the plaintiff denied jaw pain at the hospital and denied jaw problems subsequent. The medical findings on the MRI of the spine was a mild disc bulge, which is essentially an inconclusive finding for anyone of the plaintiff's age. Ultimately, as the court referenced in the question, all of the medical providers relied extensively, if not exclusively, on the plaintiff.
Was there testimony from the medical providers to that effect?
Absolutely, and that was brought out repeatedly by me at trial. And of course, if the jury believes the plaintiff, then they would believe the doctors who relied upon that. All of the things which I've just stated are all in the record and cited with record cites in my brief. Given the, this isn't a case where a fractured neck and they pull him out of a car and we could say, okay, there's an objective injury anyway. When you have a situation like here, which is a little unusual, with all these thousands or 2,400 oxys, and you kind of got to believe the plaintiff that he needed that because of pain. And that's where this testimony becomes critical. You ever been convicted of a felony? Yes. How many times? 4. That's it. We don't get into the convictions. We don't do anything else, assuming he answers it truthfully. The Braswell case turned on the fact that a court-martial conviction is not a conviction under Florida statute. In fact, even Braswell, which is the only case, I told you they weren't going to be able to cite you anything that was of this applicable time frame. The only thing they had was Braswell. Even in Braswell, they considered the fact that if this had been a conviction, even at 24 years, they might have let it in. So even at that, 2.5 times older than ours. I'll just talk about...
Would you say that Children's Palace is the closest case to your situation?
Not necessarily, Your Honor. I would say that...
Because the issue there was really similar from the sense of the credibility of the subjective medical complaints.
As to that point, absolutely, absolutely. I mean, just from the remoteness time frame, I think the Trowell case is extraordinarily close with a 2002 case with 2 convictions, one from 82 and one to 90. So you had 20 years and 12 years. But absolutely, Your Honor. And then the other case which is significant, which I'll just talk about, 2 days showing rehabilitation or reform, completely ignores this court's dictate in Howard where it said that the Florida rule is less restrictive than the federal rule. And the fact of the matter is, if I was in federal court, those earlier, the more recent convictions assuredly would come in. Under what legal basis were they then excluded in state court with a more relaxed standard? The real only evidence of reform, if you even want to consider that, and I would suggest for you that that's not anywhere in the quotient of determining remoteness from this period of time, this type of time frame, really the only evidence of reform is that the plaintiff managed to go 6 years to the time of the accident and another 4 to trial without getting arrested again. That's no different. That is absolutely no different than any of these other cases I've cited. Obviously, if Mr. Trowell, for example, with his 12 and 20-year-old convictions had a more recent conviction, they would have impeached him with that. Every one of these cases I cited, which are older than this, was reformed to the extent they didn't get arrested again. That's his evidence of reform. He didn't pick up another conviction to add to the 4 that he has. Anything else at this, I would say, would be merely repeating what I've said previously. Again, I appreciate it if there are any other questions.
No, thank you.
Thank you, Your Honors.